Colby, are
Hey,
you
good
talking?
morning, everyone. Welcome to the Thrower Symposium. This is obviously a little bit different than previous years, but we are nonetheless still excited for the 2021 edition. This has really been kind of an all hands on deck effort from everyone here, from some of the staff members here at Emory Law to other members of the Emory Law Journal. But we are excited to be here today with all of you. We are thrilled for the topic that we are dealing with. We think that it'll be a topic that everyone that is attending can, kind of have a different interest in with all the different panels that we have going forward. But I don't want to, take too much time getting into the panel. So to start off with, I will hand it over to Morgan Cloud, who is the Charles Howard Candler Professor of Law here at Emory Law. And so some of you that may have had Professor Cloud may have taken, some of his Fourth Amendment classes, but he is also, an expert on data privacy. And so I will leave it to him to introduce the panelists and get this thing started.
Thanks, Colby. I do have my areas of expertise. This technology would not be one of them. So please, Colby and Melanie and anyone else, please jump in to fix things if I disappear. I actually woke up in the middle of the night this morning, and it surprised me because I woke up thinking about our symposium, and like our speakers, our panel, our three wonderful speakers, I have done this before, and I would not usually wake up in the middle of the night thinking about the panel. And one of the reasons that I have is it's just such a remarkable time. I mean, this week, this month, to be grappling with the issues we're talking about. Sometimes these symposia can seem rather abstract. Right now, you can see behind me a picture of the street where my wife and I live in North Carolina and have since things shut down last March. We live in a little town in the mountains of Western North Carolina. Once the city got shut down, once Emory got shut down, we came up to North Carolina and have basically been here ever since. It's been just a remarkable time because we've probably consumed more stuff than ever in our lives, thanks to Amazon. I mean, if we didn't have to go through the post office, we'd have deliveries every day. It's embarrassing. We voted twice here in Georgia because our residence remains in Georgia. We voted in the general election and in a subsequent runoff election because we were able to vote absentee, even though we were exiled for health reasons. We have participated in family life. Up here at our house in the mountains, we have for years had big Thanksgiving dinners. This year we had my sister from California and her family could join us because we did it on Zoom. I can't think of a year in which the intersection between technology and data and personal behavior has been more pronounced in anybody's life. And as we now approach an impeachment trial in the Senate revolving around an insurrection aimed at our government and the transfer of power from our government, in our government, from one president and one party to another, this was something that could not, would not, should not, but would not have happened without the technology we're talking about today and the interaction of people using it. About almost exactly 2 years ago, last month, a book was published called The Age of Surveillance Capitalism by an emeritus professor at Harvard Business School named Shoshana Zuboff. And it's a very acclaimed book and deservedly so. And although the professors on our panel, Professor Alan, in my experience, going back many years, having met her work for many years, have all published wonderful stuff in this area. I want to, before I introduce them individually, just read a couple of sentences from this book. Professor Zuboff calls the oldest political questions home or exile, lord or subject, master or slave. These are eternal themes of knowledge, authority, and power that can never be settled for all time. There is no end of history. Each generation must assert its will and its imagination as new threats require us to retry the case in every age. And it's different now in the sense that we function in such a digital realm. And I'll read a couple more sentences. The digital realm is overtaking and redefining everything familiar even before we have had a chance to ponder and decide. We celebrate the networked world for the many ways in which it enriches our capabilities and prospects, but it has birthed whole new territories of anxiety, danger, and violence as the sense of a predictable future slips away. When we ask the oldest questions now, billions of people from every social strata, generation, and society must answer. The entangled dilemmas of knowledge, authority, and power are expanded to everywhere. And my own work, which used to focus on just what the government did in investigating criminals, now reaches the lives of everyone. And this is one of the remarkable developments, that the issues we're talking about today, which at one time were nicely confined to government intrusions in attempting to enforce the law, have become universal in the private lives of everyone. And the source we look at, the sources of concern, are not limited to government and may not even primarily be government anymore, but have to do with the functioning of everyday institutions in our everyday lives. We have just a wonderful panel today, and I'm going to look forward to not only introducing them, but listening to them at length. And I've been asked to give only the briefest of introductions, and I will. And as I introduce you, would you please unmute your camera just so everybody can see you? And I'll start with Professor Allen. Anita, can you unmute your camera? Hey, how are you? Professor Allen is the Vice Provost for faculty, the Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania. She's an expert on privacy law, philosophy of privacy, bioethics, and contemporary values. And she's published prolifically and not only is a well-recognized scholar, but was appointed by President Obama to serve on the Presidential Commission for the Study of Bioethical Issues. Good morning. We're delighted you can be with us. Our second, I'm just going to go through alphabetically, and unless the panelists among decide they want to do something different, we will just go alphabetically. Our second speaker is Roy Barnes, who's a former governor of Georgia and the founder of the Barnes Law Group, where he practices law as a follow-up to a long distinguished career as a public servant, both as a prosecutor and the Georgia legislature, and then as governor. Governor Barnes is particularly suited to talk to us today because he has ongoing, continuing experience litigating these issues that we're talking about today, and not just looking at them from a theoretical or academic perspective, but working and struggling with them in the courts. He was the lead counsel in the Equifax data breach case that became infamous in 2017, and I believe has just been resolved in the last year or so as a class action. And finally, Woodrow Hartzog, Professor Hartzog. Woody, are you with us here? Hey, there you are. Hi, I had to change my screen to see you. Is also, like Professor Allen, a prolific and important scholar. He's a professor of law and computer science at Northeastern University. His research and teaching focus on privacy, digital technologies, and artificial technology. In 2018, his book "Privacy's Blueprint" uh, was called one of the most important books about privacy in our time. And again, if you, I'm going to stop there, because if we were to go through the list of publications and accomplishments of our speakers, they would never get to speak. So it's just too lengthy. The way we're going to proceed, and I'll give the speakers a chance to weigh in if they want about the order, but if we proceed in alphabetical order, it will be Allen, Barnes, and Hartzog in that order. And each of our speakers is going to speak for about 10 minutes. At the end of that, we're going to have the better part of an hour for Q&A. Amy Marslana, who's, I'm seeing her picture on my screen, is going to handle Q&A. So for you who are watching, there's a Q&A function that should appear at the bottom of the Zoom screen. You can submit questions to Amy, and there's no reason to wait. You can start as soon as you have questions to send to her, and she's going to curate and feed the questions to me, and then I will ask questions on behalf of the audience. And this is not going to be a chat function for you in the audience, but you can use Q&A to submit, and Mel and I will be having some secret chats, I guess, to communicate the questions, which I'll read. With that said, I think that's enough preliminaries. And I'm going to turn to Professor Allen and say, welcome. I'm so delighted to have you here with us. I can't tell you how long I've been reading your work and enjoying your work, and I'm a big fan, and I'm just so delighted you were able to work things out to be with us today. And now we'll get out of your way and turn the mic over to you.
Thank you. Thank you so much, Professor Cloud. It is a pleasure to be on this panel with such a distinguished group, Professor Cloud, Governor Barnes, and Professor Hartzog. It's also a pleasure to be working with Emory University. Family comes from Atlanta, and I have dozens and dozens and dozens of cousins and other relatives who live in the city, and I have a feeling some of them are on the Zoom today, if that's possible. In any event, I want to start by saying that it's now a truism, in effect, that technology is jeopardizing privacy. Of course it is. And of course it has, from the invention of the portable camera, mass-produced tabloids in the 19th century, to the telephone, to the internet, to social media, to data analytics, and corporate social monitoring. You know, and sometimes privacy actually needs to be placed in jeopardy, because the digital age, it shows that privacy can be a good thing or a bad thing. But today I'm going to be focusing on the ways in which perhaps the jeopardization of privacy is a bad thing, because some good kinds of privacy, some of the best kinds of privacy, are being placed in serious jeopardy. Professor Cloud mentioned the great work of Shoshana. In addition to being a friend and a scholar, she's also, like myself, a member of the board of directors of the Electronic Privacy Information Center, which is a Washington, D.C. based think tank research organization. And she and I have had the pleasure of working together. So when the news came out that she was about to publish an op-ed last Sunday in the, you can believe that I was among the first people to read it. And the article speaks about a knowledge coup happening in the midst of a very barely checked surveillance capitalist society. We've fallen, she argues, into an economic that's allowed technology, the technology that we use and that's used against us, to quite literally threaten our democracy. Facial recognition is a pretty good example, often used these days, the perils and dangers of technology in relationship to privacy. It's a benign technology when it's just used on our personal phones to help us to more easily access our apps. But when it's used by law enforcement and by government agencies, it's potentially privacy's worst enemy. But rather than linger on the quite familiar example of facial recognition, which I do hope we'll have a chance to talk about at length later on in this symposium, I want to talk today about a topic that I think probably gets a little bit less attention in symposia like this, and that's the topic of social tracking and social listening, corporate social tracking and social listening. And I want to thank the Fondazione Prada in Milano, Italy, for inspiring me in connection with an art exhibit to think harder and to write a little bit about this important topic. So, digital culture is massively surveillant and controlling. It's panoptic and it's exploitative. It pairs social tracking technology and personal behavior synergistically, revealing who we are, where we are, what we say on social media, at work, at home, and in the streets. Individuals, organizations, and governments eagerly pay to satisfy their appetite for knowing exactly where to find customers, workers, the rest. Technology users like you and I understand that our smartphones and internet-connected devices include GPS and tracking features, but we may not all be aware of the scale of recent social tracking initiatives that threaten privacy, civil liberties, and human rights. The ACLU of Northern California exposed GeoFedia's marketing a social media monitoring product to law enforcement to surveil unions and protesters. Raytheon Riot, a defense contractor's tracking software, has piqued the interest of government security and intelligence agencies while also raising the hackles of rights advocates. I mentioned Epic, on whose board I actually chair, and I sit with Shoshana Zuboff. But Epic sued the US Department of Homeland Security, halting the development of a system of continuously tracking the locations of journalists, bloggers, and social media users, quite a threat to the First Amendment. The Electronic Frontier Foundation filed a class action lawsuit to stop AT&T, their location aggregator partners, from selling wireless customers precise real-time locations for purposes that could include anything from harmless fandom to stalking for as little as $300. Imagine something only $300 to be able to follow you in real time as you go about your life. To an extent, social tracking can be a social good, even an ethical duty, I would argue. Embracing social tracking is a way of acknowledging the moral value of accountability for our behavior, health, and others. Using wearable internet-connected devices that track exercise, sleep, and vitals can beneficially improve health and fitness. A smartphone app that enables family members to track one another's locations can help organize family life and supervise children. We call it the wife tracker in my family. The recent global coronavirus pandemic has demonstrated the beneficent potential of temporary social tracking for paramount public health purposes. The EU has been in favor of voluntary contact tracing apps designed to respect users' privacy that don't reveal people's actual locations. On the other hand, a company in Peru called Sudamericana de Fibras, this factory, the factory of this company, they use surveillance cameras and artificial intelligence in the workplace, in the warehouse, a technology that was developed in Silicon Valley to detect whether their workers were complying with social distancing mandates, and using this technology to figure out how many feet apart were all the workers in the warehouse, but having to, of course, observe them and watch them continuously in order to make those calculations. Since some consumers may appreciate targeting advertisement purposes and shopping suggestions, firms are arguably warranted in acquiring social listening and social tracking tools to improve marketing. Travelers may understandably welcome social tracking that makes identification in airports and rail stations more efficient. Social tracking and social listening that mines social network data is useful for surveillance and attempts to predict or steer future behavior. In a world of terrorism and mass violence, social tracking could have a legitimate role supporting law enforcement and national security. Bodily movements comprising massive evil merit being observed, disabled. Planting a bomb in a crowded concert hall, gunning down worshipers, pressing a knee into a man's neck until he dies. The results are public traumas worthy of aggressive deterrence, prevention, and punishment. But, and here the but is gigantic, a gigantic but social tracking is far from an unmitigated social good. Geospatial knowledge confers power. Social tracking is more antisocial than social when used for snooping or to rank people, or people, to profile people, to discriminate and subordinate people. And we've seen this happening already around the world in places like China and to some extent even in our own country. Privacy entails being let alone and opportunities for unreserved repose. Amazon and Google employees have listened to audio recorded by smart speakers Alexa and Home. Microsoft filed for a patent for a meeting insight computing system that would monitor people's bodily behavior and facial expressions during meetings in order to measure their attentiveness and so forth. The system was never deployed, I'd say fortunately, following criticism. When it comes to privacy, and when it includes unreliable facial recognition technology, gait recognition, or discriminatory algorithms, social tracking falls short. Without regulation, the location and predicted next moves of mere criminal suspects and persons of interest could be tracked by police without a warrant or probable cause. While a few jurisdictions have banned official uses of facial recognition technology, regulation of location monitoring remains sparse. Hence my decision today to not just talk about facial recognition, but to talk about location monitoring, which again was much, much less discussed and much less regulated today. The social tracking of persons in space will not only conduct, but also ethnicity, because it detects neighborhoods and neighborhoods tend to be segregated, sexual orientation, politics, and religion. Globally, the risk of human rights infringements and technological blunder will inevitably fall disproportionately on already subordinated groups, whether African Americans in America or Uyghurs in China. Race, gender, religion, caste, and class must matter as societies shape social tracking law and policy. So is social tracking of our bodily movements more good than bad or more bad than good? I think we can say that certainly right now we're not prepared to conclude that it's mostly good. Not completely good, not yet, maybe never. The public is not well informed about the scope and implications of existing tracking. Laws and ethical principles to regulate the tracking practices that we see happening today in the corporate sector especially are not in place. The technology is not error-free, and most importantly, societies remain mired in prejudice and oppressions that make the dystopian potential of location monitoring and surveillance greater still. And look forward to our conversation.
Somehow I muted myself. I'm going to use the moderator's prerogative to ask one question before we move on to Governor Barnes. Your last comments about social tracking of our bodies, beyond facial recognition, but our bodies, now occur in a realm in which people spend a lot of money for the opportunity to buy devices to help companies do that. You know, with people wearing just watches, for example, Fitbit watches or Apple watches. Part of the purpose of that is to have my route measured, have the path of my walk measured, have my heartbeat measured while I'm doing that. And this information is voluntarily given to companies. And I think we're now at stage of technological use and adoption by people, that it's not unfair to say, most of you know that this data is going to the company and being gathered. Does that impact your analysis at all? The fact that some of this location information, maybe lots of it, is turned over voluntarily?
So it's certainly the case that we as consumers are now complicit in the big data grab, because we are voluntarily using, as you point out, wearable health devices. We're voluntarily using location tracking devices to measure the length of our walks and bike rides and so forth. But I disagree with you, your premise that people by now understand the implications of what they do. I don't think people have a clear understanding that that there's a company out there who, when they use these technologies, may be gathering that data, using that data, analyzing that data, and sharing that data. The terms of service are seldom read or understood by consumers. I've not seen a single credible study suggesting that we understand and read own experience. This is, purely anecdotal. We can go back and forth about our experiences. But my experience is that people, even very well-educated people, people who even may not read the terms of service of their telephones, their apps, and so forth. So I think we're a long way from being able to say that this voluntary participation in the data grab is knowing and does not merit some paternalistic, as it were, intervention from government.
So, and I said, thank you. So you've really set the stage for the rest of our conversation on this topic. And I, based upon my conversations with Governor Barnes and Professor Hartzog, they may want to pick up some of those same themes, particularly terms of service, of which no one ever reads at all, I think, unless they're doing it to write a paper. Governor Barnes, I know you're going to have a different, probably a different perspective. I'm looking forward to hearing it.
There you go. I want to talk about what happens in the courtroom. I want to give a much more practical effect. And I suggest to you that what happens is in a courtroom is the most important regulatory act there is. We have safer cars today, not because of federal regulations, but because manufacturers of automobiles do not want to be hit with products liability cases on obvious defects. And the same thing happens in the breach of data, or really, as I say, who owns the information on me? Because that's really Professor Allen talked a little bit about that, but that's the basis of these cases that we have litigated. So I want to give a little background and also some thoughts and some observations that I've had as a result of litigating these cases. We've been involved in leadership positions in 3 major cases. Home Depot, which up until that time was the largest data breach, up until, of course, Equifax. One that was much less, Arby's, because credit card numbers were being hacked, but mainly Equifax. Equifax was massive. It was estimated that up to half of the population of the United States had information that was hacked over a substantial period of time in Equifax, because not only does Equifax keep credit information where you have social security numbers and you have background numbers like where you live, but many times you had place of birth, where you would have place of birth, and even mother's maiden name. And then, which is all you need to get to any information anywhere. We undertook the case, and it was, as I said, a massive case. And one of the things that we learned as a practical matter is there is massive amounts of information, massive amounts of data, which also burdens preparing the case for a trial. The fact that you will have to go through tens of millions of pages, which is impossible to do using just reviewing documents as we all used to do. Now, remarkably, we use artificial intelligence from companies to review the data that we will use in the court. We're representing the state of Georgia in the opioid litigation against the distributors and manufacturers. We already have 10 million pages that have been ingested. We estimate there will be 50 million before it's over with. You could never review those, even with good search terms. How do you determine what's privileged and other things? There's a company called Disco that uses artificial intelligence to teach itself what to look for. So in massive data breach cases, you use technology to be able to make them manageable. What concerned us in the Equifax case was that the proof of damages and the proof of injury, which is a concrete injury, is something that is required, of course, for Article 3 standing, and the Supreme Court of the United States has really gone off in making you prove standing in every case. And one of the things that I want to emphasize in this, and this is on the practical side, is you have to build personal relationships with the other side. One of the reasons Equifax moved pretty quickly was because David Balzer at King and Spalding was a good friend of mine. And I've known David and his family for years. We've litigated. And from the very beginning, we were very cooperative with each other. If you don't have, the reason that's important is if you don't build those personal relationships, then the time of litigation, what I call attrition, litigation by attrition, will prevent any remedy being given to those whose data and information has been taken. I have a very strong view, as you might imagine, as an advocate, that my information on me belongs to me. And it is a property right that I have that you have no right to trespass upon. And in fact, and of course, I've read all the articles and the books saying, well, this is so ubiquitous now that we have to weigh the good and the bad. It belongs to me. And that's what I tell judges when this has come up. Now, Equifax. It was, as I said, it was the largest data breach in history. Most people thought that the greatest danger was in credit cards. Oh, they got my credit card number, and they're going to use create a bunch of fraudulent accounts. I will tell you that credit card numbers get auctioned off on the dark web as soon as they're stolen. And the bigger the credit card, that is an American Express Gold card, brings more than a Visa card. And an American Express Platinum card brings, they sell them in a matter of minutes. But within 6 months, generally, the credit card fraud is over. It is what they determine from the other sources, and this is what concerned me in Equifax was even more. Equifax also aggregated health information. Why, you would say, is Equifax aggregating health information? Because they were selling the health information to life insurance and health insurance companies to determine rating risk. And I was really more concerned about the health information that was taken and utilized, because it doesn't have a short lifespan. Your credit card number is going to get changed as soon as you report you've been hacked. And your liability on credit card theft, if you timely report it, is limited. On health information, they can use it for things for years. And you'd say, well, what in the world, who would buy health information? There are a lot of folks that would illegally buy health information. Even sovereign governments are interested. We all know about the dispute with China and I won't go through the story, but coming in and offering to set up very cheap testing facilities for COVID. Well, the reason they were doing that is to get the health information. And yes, government came in and says, I don't believe I'd do that. They told the state of Washington that they would not do that. So there's a broader market out there, not only governments, unfriendly governments, but also, remember, fraudsters. If fraudsters get into that health information, they can make individual pleas in scams for specific diseases. And it's also easy, if they get your credit card number, again, the new number, to be able to use it to verify. Now, I know I'm going over, and I want to just make 2 points. So where do we stand in this litigation in the future? Okay, because I think that's very important. As I said, it is lawsuits that control behavior of those that are entrusted with our information. And if there's vigorous litigation out there, very tough litigation, you'll have the best lawyers in the country in these cases, then there is a self-regulatory effort there that's not dependent on government. Companies say, listen, we could get hit here so hard that we have to be more careful. I have told my lawyers not to take any more data breach cases. And you know why? There has been so many data breaches. How do I prove proximate cause? How in the world do I show that it came from Equifax, or the breach on the Office of Personnel Management, or the NSA breach, or all of these other breaches? And I've told my lawyers here, I said, no more data breach cases. We're out of the business. The Equifax case is on appeal and we're done. So the question that I have as a practitioner, how does this regulation by court litigation, which is the most effective? I've told folks, you want to do away with the excessive use of force by police officers, take away qualified immunity and let the trial lawyers set the standards, and there won't be, you'll reduce excessive force. How are we going to enforce it in the future? The FTC, who we worked with in the Equifax case, they're just overwhelmed. The statute, and then the other thing that happens is say, well, can't we get around the proximate cause if there's statutory damages that are set by privacy statutes that you can sue on? Well, the federal courts, particularly the Supreme Court, says that doesn't create standing. I think it's a terrible case, but they say it does not create standing just because there's a statutory damages that can be awarded to individuals for having the data breached. In summary, this is not going to get better or easier for some time. We're all out there feeling along on how do you control your information that you own to make sure that it is done and not sold on the open market and they make money off of my information. How we do that? Hopefully we'll find the answer in this symposium.
Thanks, Governor. I appreciate it. And if we do find the answer, we'll all be rich and famous ourselves. Professor Hartzog, there's a wealth of things have been thrown out already. I know the raising of issues of of medical information, touches on work both that you and Professor Allen have done, and of course the idea of how do we regulate is profound. And I'm not going to try to steer your comments, but I can't have listened to Governor Barnes and not ask a question that's always on my mind: is government even remotely up to the task of regulating this behavior? Anyway, I'm not going to try to shape what you do. I look forward to hearing your comments, and then we'll take questions. We're starting to get some questions from the audience, and I would encourage the audience to use the Q&A function to ask questions. Professor Hartzog.
Thank you so much. And I'd just like to say it's an honor to be on this panel. I've been, Professor Allen, I'm following your work for so long, and it actually has influenced a lot of what I'm about to say today. And Governor Barnes, I completely agree with you with the need for private litigation as an accountability mechanism, which is going to be relevant today. But I'd actually like to begin with a story. And the story that I want to start with is data privacy's love affair with individual autonomy, and how it has led us to a place that we might not be happy with, and sort of where it's taken us. So the story of modern US data privacy law begins in my mind, in the 1970s, when the electronic database was first starting to become commercially deployed, and people started to begin getting worried for the first time about the ability to aggregate lots of different amounts of data together, make it searchable, make it live in a pristine state. And there was a general sense that we needed some sort of approach to regulate data processing such that it was fair, so that we could do so in a sustainable way, and that people would avoid long-term harm. And the way in which around the world these principles got settled on is this concept known as the fair information practices. Many of you are probably intuitively familiar with the fair information practices if you're not explicitly familiar with them. It's the notion that you should have some sort of control over your personal information, that you should have notice about what kind of data is being collected, what kind of data is actually being shared with others, what are the safeguards that are being put into place. These are all things that are becoming intuitively familiar to us, if for no other reason than we keep getting email after email from companies saying, we've updated our terms of use, would you like to click the I agree button? And the way in which these fair information practices ultimately manifested is in a series of ways that led us to what I'm going to argue is basically a view of data privacy completely centered around ideals of control over personal information and consent, the idea that we will give consent before anyone can use our personal information. This started with the Privacy Act, which was one of the very first statutes in the United States that was based around the fair information practices. You can see the fair information practices in many different forms, like the Gramm-Leach-Bliley Act or the Fair Credit Reporting Act, and the Federal Trade Commission, when it first started to regulate privacy in the late 1990s, looked around, and because the internet was young and they didn't want to over-regulate it, they adopted another control and consent style regime that we call notice and choice, where they said, we're not going to explicitly sort of tell you what you can and can't do, at least not at first. But you have to do whatever you promise. And the place that they looked at that was the privacy policies. And this has resulted in now, as we've seen the sort of next iteration of privacy laws around the world, we see that, well, maybe the control and consent regimes aren't working so well. And so we see a little bit of evolution in those laws. So the GDPR has incorporated lots of different structural protections in the European Union. The CCPA and the latest revision to California's privacy law have a lot of rights that seek to sort of go beyond standard control and consent regimes. And yet, there is a gravitational pull that brings all these laws back to this notion that we should have control in our personal information, and that you shouldn't be able to do anything unless you get our consent. Canada just yesterday came out against AI company, facial recognition company, Clearview AI, saying that they're basically violating Canada's data protection law for failure to get consent, right? So consent and control tends to sort of be the absolute anchor, anchoring all of these other things. And the thing that I want to talk about today is, what if we got it wrong? What if in the 1970s, our idea of building all of our frameworks around this idea that we should have control over personal information and that we should give consent before anything happens with our data isn't actually the best path for data privacy in the United States? Because there's good reason to believe that consent and control is not only impossible or theoretically impractical at scale, but also that it doesn't solve the right problems, that it doesn't protect social values and vulnerable populations, and that it, in short, is no match for the personal data industrial complex. Now, there's a lot of scholars that are writing about that particular question. And the thing that I want to talk about today is one aspect of that, is that if it's true, in fact, that control and consent isn't up to the task, then there's another concept that I argue today that we have not reckoned with, and that is the concept of path dependency. So in path dependency, there are scholars that study path dependency in lots of different fields. And the idea of path dependency can be seen in things like technology. So for example, many of you are probably sitting directly in front of a QWERTY style keyboard, right? QWERTY. There's reason to believe that this isn't the optimal way for keys to be arranged on a keyboard. But you know what? It's never changing, right? We are locked into the QWERTY keyboard because the switching costs are simply too high. This is what's known as path dependency, right? When the switching costs are simply too high to do it, we are stuck on this path. Putting power lines above ground rather than below ground maybe wasn't the best idea. We're stuck with it, right? Path dependency also exists with norms. The idea that we are sort of compelled to act in ways that we previously have and that everyone else always does because that's the way we've always done it, right? And anyone familiar with that sentiment can feel how path dependency exists in norms. Path dependency also exists within economics and political institutions. So the idea that changes sometimes are hard to make because of everything that came before, because there's simply too much heavy lifting organizationally and structurally to meaningfully change things. So, my argument then is that if we do want to change privacy law for the better, to meet the modern task of, as Shoshana Zuboff calls, surveillance capitalism, or as Julia Cohen has called, information capitalism, then we must reckon with the path dependency that we are on around control and around consent so that we can explicitly overcome, right, embrace those switching costs and overcome them. Otherwise, that gravitational pull will always bring us back within a framework that's going to limit fully what we can accomplish. So, and I want to build upon that. So why is path dependency bad? I think there are a couple of reasons why we might want to break our path dependency on control and consent regime. One of which is, as I said before, I think that control and consent is probably impossible at scale. Anyone that's clicked an I agree button or had a preset menu of choices given to them where they have to pick something, you think you're exercising control. But of course, the entire environment was architected to get you to choose one of two things, both of which would be fine to the company, right? It's not real control. It's not real meaningful consent. Another reason to think why this path dependency is a bad thing is that it doesn't capture social interests. So control and consent are built around ideas of individual autonomy, right? The idea that what is best for me in this particular situation, right? This is my information and this is my life. And that's great and that's good, but the collective wisdom of billions of people doesn't necessarily watch out for things like our social collective well-being, political institutions, democracy, our social discourse, right? We don't sort of have that calculus in mind when we make these individual autonomy decisions. Also, when we rely upon the collective wisdom of billions of people who are voting one at a time, they aren't necessarily taking in the interests of vulnerable and marginalized communities, people of color, people of the LGBTQ community, and other people who will be marginalized when the will of the people is collectively expressed by majority rule and then instantiated in technologies. And then another reason why I think that this path dependency could be bad, and here's the thing that I've been really thinking about a lot, is that it limits our regulatory imagination. Because when we try to build upon something, almost inevitably, we ride the rail of consent and control. For example, the California Consumer Privacy Act was basically a sort of subset of a little control and consent rules that came from the GDPR, which was based on the EU Privacy Directive, which was based on the Privacy Act. And we're seeing it happen in the United States now. So Virginia just yesterday passed a very interesting data privacy law that was still based on consent and control. And I predict that the dominoes are now going to start to fall, where other states are going to start introducing other laws that will all be based around consent and control. And it limits what's possible because frankly, I don't think we've been exercising our regulatory imaginations that well because we are locked in this path dependency of consent and control. But even beyond that, let me argue that path dependency limits our imaginations about what the world could be like. When we think about privacy as consent and control, we don't ask a lot of other questions, right? Instead, we're so focused on this individual autonomy that we miss out on questions like, how do we go about properly valuing what our life was like before smartphones? Are smartphones good or smartphones bad? I spent a lot of time staring at them. Consent and control regimes don't answer that question, right? Is the labor that we use to write letters rather than pursuing these efficiency goals better or worse? These consent regimes limit the sort of world that we ask. And so I'll just conclude by saying that I think that in order to build a better privacy regime, I think it's worth tackling not only the entire framework around consent and control, but also the switching costs that will have to be embraced if we're going to move on it. Because if we don't recognize this path dependency, we're going to do what we've always done, and we're going to get what we've always gotten. Thank you very much.
Yeah, thank you very much. And I think I'll start my questions with the very provocative point that Professor Hartzog making about consent and control, which inevitably is focused on the choice of individuals. And that's not surprising. I don't think in any context, certainly not in the context of our social and political systems and history. I'll just say that as a way of kind of example, one of my brilliant colleagues at Emory is a woman named Martha Feynman, and she has developed a system called vulnerability studies that is just the most provocative, creative critique of contemporary institutions and how to rethink the world to accomplish some of the things you just mentioned, Professor Hartzog, collective good, social needs, institutional needs. But one of the problems that bumps up against is that what you're calling path dependency, we might call fundamental notions of our society. And the idea of individuality as opposed to collective decision making over individual behavior is, of course, fundamental in our social institutions, our political institutions, our cultural history. So I would like to ask not just you, but the entire panel, if there is, in your point of view, just picking up on Professor Hartzog's very provocative suggestion, is there, as a practical matter, any way that the regime of control is going to change from consent and control in the near future? Are we going to have a system in which there's some attempt to regulate or moderate use or limit use of these technologies by government and private actors? That's something other than consent and control. And I would say that, in a sense, Professor Hartzog, kind of by using the examples you've just used at the end of Virginia and otherwise, kind of suggests that the answer is no, it's not going to change. We're going to stick with this consent and control model. But I'm really interested to know what all three of you have to say about that. And I'll start with Professor Allen, just because she's been off for long enough. It's time to get her back to work. So.
Thank you very much. Love the perspective that was just laid in terms of being provocative. So my response to it is that I think to ask the question, whose interest does consent and control, or notice and consent, whose interest does that serve? I think I agree with Professor Cloud that it's more than just a path dependence point. It's a point about ideology and about governing ideology and who that ideology is. And arguably, it is very much in the interest of big tech for us to maintain a thin version of notice and consent, or consent and control, because that's what makes it easiest for the corporate sector to get what they want out of us. It butt heads with what Governor Barnes was calling our, property interest in our. So I think we need to attack the ideology as such, attack the power dynamic here as such, name it and attack it as such, that calling it path dependence sort of lets off the hook those privileged and powerful forces in our society that are keeping us mired in this inadequate notion. The other thing I would say is that while people sometimes think that you have to be for control and consent if you're for autonomy, I think the opposite, that you take autonomy seriously. If you really believe that human beings have, as rational, free creatures on this earth, are entitled to not be treated as means, but as they are ends in themselves, if that's your deep notion of dignity, you would not hang on in this environment to a notice and consent type model. You would begin to realize that you need to have a more collective response that might well include more legislation, more private lawsuits, and in particular, there's this idea being floated, a privacy protection agency, right, of government that would serve to regulate and enforce regulations in a much more meaningful and robust way that can be done through the FTC or through private litigation at this time.
I'm going to jump in again. My concern, Professor Allen, is first speaking of capture, who's captured more than our federal agencies in terms of being captured by industries that they're supposed to regulate? So I wonder about the efficacy of that. We keep running into situations where the agencies aren't doing what needs to be done to protect either collective or individual interests. And second, my experience in working with legislation in these areas is that I've pretty much given up hope that Congress is going to do anything that's worthwhile. They just, the pace of change, the impact of interest groups is so substantial. I'm just very, very skeptical about whether, at least at the national level, there's going to be anything that happens that's going to be ultimately very effective. And I'd love to be disabused of my cynicism. And so maybe I'll turn that over to Professor Allen and then Governor Barnes.
I understand your sense that government or agencies are not the solution, but I think we've seen some evidence from the past that schemes of regulation can be effective. As flawed as HIPAA is, HIPAA did have a privacy rule that has somewhat addressed the problem of healthcare privacy in a whole framework. The education privacy law, the Privacy Act itself, the driver's protection privacy law, the genetic information privacy law. These laws, I mean, they're not perfect. They are, I think, much too still mired in notice and consent type modeling, but they have incrementally moved us forward. So I think that we need to maintain hope that through our political action, getting people in the right roles in Congress, in the House, in the Senate, the right staff in agencies, we could use our collective power to confront the power of the private sector in particular, and the power of the government when it's not working for us to improve our privacy. So I'm not yet giving up on that, not yet.
Governor
Point
Barnes.
granted, but I'm not giving up yet.
Governor Barnes.
I look at things from that client that walks in the door, sits down at my desk and says, such and such has happened and they've defrauded me or they got my health information. I can just hear myself tell them, well, we have decided that as a society that we should allow a full use of that information. Now, you know what that fellow's going to say or a lady's going to say? She said, they're going to say, that's crazy. It's my information. Now, Professor Allen is correct in that HIPAA probably had the greatest effect of any privacy law I've seen. And in fact, it even got down to this effect. Defense lawyers in a wreck case would generally go see a doctor before they took his deposition. Tell me about this patient. And that stopped after HIPAA. After the court came in and says, no, you can't, unless there's permission, consent, you can't talk about somebody else's health, your patient's health, without that patient being present or consenting. Now, yes, there is a place for statutes and to set standards, but don't put all your eggs in the basket that the government's going to regulate. And the reason is, and listen, I take this from experience of being in government for over half of my life. They get co-opted. They get co-opted and they do not provide the regulation. Allow private litigants a cause of action to enforce those statutes, and you will have more and greater enforcement than anything else. The Fair Debt Protection Act, the FTC said you couldn't have abusive ways to collect debt, but when the Fair Debt Protection Act was enacted and you can file suits on it, that's what moves things. And that is what's going to move consent, in my view. The whole issue of consent on privacy. Last thing, no, nobody sits around and reads those terms of service, except us old lawyer. I've got two big magnifying glasses. I sit there and read them, and read the terms and conditions on on credit cards. Yes, I do, looking for some little thing. I would rather fight that battle in the court, saying, listen, these things are contracts of adhesion. You got to give me a little relief, rather than just relying on some government agency to come in and find somebody $1,000 for not doing it.
Professor Hartzog, I think it's your turn. You started this thing, so why don't you
sure.
pick up?
First, Morgan, just to respond to your concern about agency capture, I just wanted to quickly note that I do think that maybe the Federal Trade Commission has been more resistant to capture than maybe some other organizations, and that one of the reasons we're seeing it just based on its structure. But it's one of the reasons that it's lacked a lot of punch is, I think, a lack of resources and statutory authority to levy certain kinds of enforcements. And then to respond to Professor Allen's statement that it really is an ideology, I completely agree about that. And I actually wasn't explicit about what was the path dependency, what was causing the path dependency. I also wanted to, I rarely get a chance to put a plug in, but your book was very influential actually in my thinking around potential misuses of things like offering too much control to people in the ways in which that then gets abused and is in fact counter to autonomy interests. So I think that the ideology is in fact consent and control, but the reason that there's a path dependency is there are two. There's legal reasons and there are technical reasons. And the legal reasons can be broken down to the scattershot nature of our approach to US privacy. So we don't have one law that can be quickly changed, but there's a much heavier lift if we want to change privacy law around the world, particularly because preemption is sort of the third rail in Congress right now. And Morgan, I share your skepticism about whether Congress is going to be able to pass some omnibus rule that is really meaningfully effective. But the other path dependency that has created this, locked us into consent and control, was the choice to let the Federal Trade Commission be our national privacy regulator in the first place, which is of course charged with protecting individuals as they interact within the market, right? And so that also is sort of a structural path dependency. To say nothing of technological path dependency, because we've created all of these user interfaces that are designed to give us the illusion of control and consent, privacy settings that we push and agree buttons, right? That's also sort of creating switching costs. And the question as to whether we can get out of this and what can we do, I actually am also very optimistic, and maybe I'm a let 1,000 flowers bloom kind of person, but I think that both regulatory agencies and individuals bringing private causes of action both have critical roles to play in this ecosystem. And there are ways out of this to move beyond control and consent would be to revitalize relational duties of loyalty, duties of care, duties of confidentiality. We could start creating substantive rules. I've been heartened to see and have advocated for outright bans on facial recognition that's happening at the city level. Portland actually engaged in a ban for both government and industry use, public uses, which I thought was really interesting. Equitable remedies are something that we haven't really looked into a lot, but the Federal Trade Commission just required a company to delete a massive data set and the algorithms that learned on it. That's a remarkable equitable remedy. So I remain optimistic if we take a multi-pronged approach to move beyond control and consent and break the path dependency.
Let me add just something that Professor Hartzog talked about. In the settlement, both of Home Depot and particularly in Equifax, one of the greatest parts of it, and it took the longest to negotiate, was the equitable changes and a monitoring. We required in the settlement, they will spend close to $1 billion implementing this, because we solved the problems, and then we made for 3 years or 5 years, I can't remember, made them pay for an auditor to come in that we chose, that is representatives of the plaintiffs, to check and make sure they had made these changes. And Professor Hartzog is right about this too. FTC has been the least captured, but and we work with the FTC a lot. I stayed in Washington a lot working all of this out, our whole team did. But they can't do it alone. Gosh, they have so much. I mean, they are just overwhelmed. And, there's a lot of litigation now about the extent of their remedies, and maybe that the court has been too broad in allowing, in the past, has been too broad in allowing the remedies. And that's something the Supreme Court has been talking about too. So I do think it's a partnership of government and it's a partner and private litigation. However, private litigation, we brought the framework to the FTC. They took, our talks with them were preliminary, but we kept them involved on what we were seeking. And they made suggestions about what we should put into the injunctive. And then in the settlement is course, we approved the settlement. The judge made that an order, but then the FTC entered a consent order that took so they could enforce also the injunctive parts of the case. So there is a place there, and that's the only way that you can. These cases, let me tell you something. A normal person would not undertake these cases. I mean, you can spend $1 million or $2 million in advance cost in a heartbeat. I have spent $1 million in an afternoon preparing some of these cases. And, you know, there's not a lot of lawyers going to say, well, I'm going to throw a couple of $1 million out there to see if I recover on this case. It's tough. It's really tough. But the greatest problem I see in private litigation is this issue of proving proximate cause. And that is a place where regulation and statutory interpretation could really help. And I'll hush on that.
No, well, thank you. Professor Allen?
Yeah, I want to respond to that. So as Governor Barnes is talking, I'm suddenly getting images of Ralph Nader in my mind. You know? Ralph Nader seized the moment to become the super litigator in product liability realm, you know, to, and, you know, I think there's no one can deny that Ralph Nader single-handedly changed the face of product liability law in the United States. In fact, he's created a museum up in Connecticut, the Museum of Tort Law, something that Vince Woody. But so litigation is effective, but limitation has its limitations, and you just pointed out some of the reasons why Governor Barnes, only some lawyers can afford to take these cases, and then beyond that, of course, only some potentially deserving plaintiffs will have access to the good lawyers like yourself who are going to be able to bring these cases and afford to bring these cases successfully. So it's not a well-distributed solution to the problem to leave it in the hands of the exigencies of private litigation in this country. And it's a shame, but the torts are not morally well grounded in terms of accessibility and fairness. And of course, as we know, also our judges are not necessarily without their own political agendas, biases, leanings, and so forth. So you don't really escape some of the problems you have with the legislation by moving everything into the court system. Have a problem in this area of privacy and data protection, of the complexity of these cases and the jury system. I mean, it's just enormously complicated, enormously difficult to really know what's going on. And so you have unfortunately, charisma may be a bigger factor than necessarily than justice, and somehow some of these cases come out. But I agree with what I think is here, which is that we need a multi-pronged approach, a place for some government action, some agency action, some legislation, and some regulation. There's a place for private litigation brought by really aggressive, well-heeled lawyers, and there's an area for individual and I think that all three of those things are true, but we are facing a massive problem right now that has gotten far out of control. And I think we do need to start to map out some solutions, or just basically give up posts, because it's getting to be just about as horrific as Shoshana Zuboff described in her work.
Well, I want to add a prong for us to talk about. This is kind of built into some of the questions that we've had. There've been questions about what Governor Barnes referred to as the contracts of adhesion on our click-through agreements. Do you agree to our terms of service or forever give up trying to use our technology? Not exactly an equitable agreement. But one of the other areas that we haven't touched on at all, and it's just, this is the United States, and I think we have to talk about the private sector and whether there are private sector profit-driven remedies. For example, there are recent stories in the news about, I think it's fair to call them secret Facebook, Google agreements, which suggest, the sharing of information and the profiteering that comes from gathering and selling what Professor Zuboff calls behavioral surplus, for example, the analysis of our online behavior, conflicts with it's this wonderful ongoing conflict between Facebook and Apple, where Apple has generally taken a profit-oriented position. We're going to be known as the protectors of privacy. And so they're churning out new ideas about providing information to users of their technology about what happens with their data, including what apps are doing. And Facebook is responding, saying, you're going to ruin small businesses by releasing this data, which they really mean is they're going to cut our Facebook profits. And so I do wonder, in this conflict between corporations struggling to get control of the marketplace, if there's not some possible solution to add to the arsenal of regulatory agencies and private litigation and legislation. And I'm going to just open, if anybody wants to touch that, have at it.
Well, I'm never, don't ever ask a trial lawyer if he wants to say something. Professor Allen and Professor Hartzog are hitting on some of the solutions. There is a need for legislation. For example, if I were writing it, I would say you cannot, in your terms of service, exempt yourself from liability by the terms of service if there is a abuse of it. And you cannot require arbitration because that's what you're doing. There is, and these are the standards of privacy, and the FTC and private litigants can be able to both enforce. And Professor Allen is correct. And it's not only in these actions. There's a disproportionate distribution of access to civil litigation. And all of these ideas of restricting class actions, for example, which culminated in pushing all class actions almost to federal court under the federal, the most misnamed act in America, called the Fair Class Action Act, FACA, and giving it jurisdiction. And that's why I worry about lobbyists and the effect of, like you do, Professor Emory, on legislation in Congress, making that more difficult. But it is accomplishable. It is accomplishable to do. Should there, for example, I just use this as an example, but when we had the burst of consumer litigation, FACTA, Fair Business Practices Act in Georgia, the Fair Debt Collection Practices Act, we limited the amount that could be awarded in class actions. I'm not a fan of that. But still, if you set it high enough and there are enough actions being brought, then it can be an effective regulatory method. What worries me is, as Professor Morgan has pointed out, is it seems that our members of Congress do not represent us, but represent whoever is the lobbyist de jure. I once said in the Georgia legislature, I was mad with the legislator that I was talking with one day. And I said, you're just bought and sold by, I call the name of the company. I said, we should do like NASCAR does. We should require legislators to have patches on their shirt, on their coats that's sponsored by, and then whoever you're sponsored by, at least that's full disclosure. So, but don't come down here and tell me that you think this is good for the public. It's not. So it is a terribly tough issue. And those of us who litigate in this field, we all the time are hitting block walls and brick walls. I mean, it is very tough. But I may have that judge that's got a predisposition, but let me make my argument. As I told one judge a few years ago that was going after my side, I said, Judge, I said, it's a mighty thin pancake that doesn't have two sides. I said, so you let me, before you make up your mind, give me a fair shot. Well, you know, those kind of interactions we can work around. And I think that there's not been enough national discourse on whose information this is and to what extent can capitalism use it to make money. And we need to have that discussion.
And I'm going to jump in for just a second. Obviously, for a fair shot, it's Professor Hartzog's turn, but I know that Professor Allen has to leave very quickly. And is there anything that you would like to add before you have to go meet your other commitments, Professor Allen?
Just that industry self-regulation is a good thing when you can get it. But we know that there's a lot of system gaming when you have that approach. We also know that people will use moral cover and do the minimal amount that has to be done to seem to be, you know, but ultimately it's going to be the bottom line, which is the obligations of shareholders to make money and stay sold. I'm not too keen on the idea of leaving it to involve these problems. On the other hand, I believe that there's so much technology available that if these companies do a better job with protecting us, they could. And it would cost us something, but it could happen. More encryption, better cybersecurity measures all around to make it less likely that hacking will succeed in a data breach. So I'm not that confident right now that industry has or done all that it could in the absence or without regulation. So again, multi-approach, the self-regulation, the corporate ethics, the legislation, the courts. Let's do it all to get the job done. And I apologize, I do have to teach torts at 10 o'clock. And I've so enjoyed the panel, and I look forward to future conversations with this lovely group. So thank you very much.
Thank you for joining us. Now, Professor Hartzog, it's there's been a lot tossed out, and it's certainly at very least your turn to jump in with your responses, in part because you've triggered a lot of this.
Sure. Well, I mean, as usual, Professor Allen said it probably much more elegantly than I could. But I do think to answer Morgan, your question directly about is there a role for self-regulatory efforts? I think is what you were asking. So I think that there may be, but only if the incentives are properly aligned through government actions. Because otherwise, I think that there are times where you sort of get a windfall with companies like Apple deciding to protect privacy by making a decision to limit certain kinds of ad tracking, for example, that Facebook got so upset about that I think they put a full-page ad out in the newspaper. But otherwise, I think that those are just sort of they're sort of fluctuations, and in order to consistently have companies act, I think, in favor of solutions that protect people's whole notions of privacy and socially valuable notions of privacy, I think you've got to set the incentives through regulation.
Well, I am fairly confident that the market itself is not going to drive companies that are making unprecedented in the history of the world amounts of money and profits to change their behavior. Though I do know, you don't know, but 20 years ago, Google had no greater cheerleader in the Southeast than I. When Google was reinvesting its resources and using its study of consumer behavior online, user behavior online, to improve the algorithms, to improve the search results, this was, it was the greatest search engine yet at that time. Now that You know, and there's Professor Zuboff does a wonderful job in her book of tracing how that ended and how the drive for using behavioral surplus to produce these huge amounts of income came about. But it does indicate that companies can shift and change their behavior if they get economic incentives. And you know, if there were ways, for example, with successful plaintiffs' lawsuits, to give companies economic incentives to behave in a different way, then I think that would happen. I'm going to, you know, we're very close to the end of our allotted time. There's implicit in our conversation, we've answered many, if not all, of the questions that our audience has posed. I'm just going to do a quick look and see if there's anything. I think that we've, as much as we're going to, covered that. So I'm going to ask each of you, and I'll start with you, Professor Hartzog, if there are any final comments you want to make. We've got about 3 minutes left. So any comments you want to make about any of our topics today?
Sure. So I guess I'll just end with a note of optimism. I always feel like I come in and, you know, introductory wise, I say everything is, you know, all on fire and it's all bad. And I actually am optimistic because I do think that there's a path for the future that moves beyond just the I agree button and this feeling of fatalism. And you hear so much conversation around, you know, privacy is dead and we've lost it all. I think we've got so much left to protect. And I think that I'm really heartened by the national conversation. And our first step, I think, is just sort of moving beyond these notions of if I give consent, then everything is protected, right? And as long as that's step one, and once we move beyond that, I think that there's a lot that's potentially available in our national conversation. Privacy is about power, privacy is about democracy, privacy is about social well-being. And as soon as we collectively come to that realization, the better we can chart our national policy and conversation.
Well, thank you. We're all looking for bits of glimmers of optimism these days. Governor Barnes, will you give us you'll get the last word on this.
I do agree with Professor Hartzog. I am optimistic. We're entering, you know, if you study politics, you have conservative reactionary times and you have progressive reactionary times. We're entering, in my view, a progressive time. And there is some need for some legislation. We need to say, when you click, this is what you're doing. And you need to make sure that you know this is what you're doing. And then that's not enough. You've got to prohibit the companies from doing certain things with the information. And with that, and with the regulation or the legislation and some litigation that I think could be effective, I'm optimistic. You know, I'm optimistic. I'm a plaintiff's lawyer. I'm an optimistic guy. And so that we can make some changes that really make a difference. But most important, in my view, is we need to raise the level of national discourse on this and decide what we're going to do. And that's difficult because it does seem to be technical. You get lost in the information, everything. Thank you for letting me be here, Old Country Lawyer.
Well, thank you for joining us, and Professor Hartzog, thank you, and thanks to Professor Allen. We're right at our time, and I'm going to turn this back over to Colby Moore to wrap this up.
Yeah, absolutely. Thank you to all our panelists, and thank you, Professor Cloud, for being the moderator for this. I know that everyone, it was a great start to the day. So we currently have a 30-minute break before the keynote session. So you all, when you registered, should have gotten the 4 different Zoom links for each of the sessions. So we're going to end this in just a moment, this session, but just before 10:30, if you could get on the next Zoom link, that would be wonderful. If you have any problems with the Zoom links, feel free to shoot me an email. It is colby.moore@emory.edu. Spelling of my name hopefully is just below my picture. So colby.moore@emory.edu. If you have any problems, feel free to shoot me an email. But we look forward to seeing you all at 10:30, and thank you all to the panelists again.